So 2 states have recently raised the age of that young people are considered juveniles within the juvenile justice system, New York and Vermont. And our moderator, Marcy Mistrett, she's the CEO of the Campaign for Youth Justice and was one of the advocacy organizations that had played a substantial role in making that happen, as well as our other 2 panelists. So I'll turn it over to Marcy.
Thanks, Joe. Good morning, everybody. How are you? Good. Well, I'm going to let these guys introduce themselves in a second, but real quickly, the term raise the age means a lot of different things to a lot of different people. What we are going to be talking about today primarily is raising the age of criminal responsibility, okay? And so that means the age at which children are considered adults by the legal system. And I'll touch a little bit more later on the other ways that people are using that term. But what I do want to say is, in the past decade, we've moved from 13 states who set that bar below the age of 18. We're now down to 4. So this is a campaign that has been very intentional. It's been all corners of the country, and the reason we have focused, and it's winnable, right? And the reason that we focused on it is that age demarcation is the biggest driver of children into the adult criminal justice system. Right? So by changing raise the age, yes. So when you say under 18, are you talking about in all instances? No, there is carve-outs in every single solitary state. Yes. So thank you for asking that question. But what it has done is it's moved the number of children from 250,000 children prosecuted every year as adults down to about 76,000. We have 5 states who have passed the law that are just starting to implement. When those 5 states implement, we will knock that number down in half again. So you're looking at, within a decade or maybe 12 years of time, you are going to see a drop from 250,000 children prosecuted as adults down to about 40. Now, 40,000 is still a staggering number, and I don't want to lose track of that. But this is a reform that closes that front door. And so I'm here with 2 folks, and before we hear from them, I am going to show you a little bit of a video when we kick off New York. But Julia is here with the Raise the Age campaign in New York, and I want us all to give her a round of applause because she's in day 4 of implementation, and it's taking time out of her schedule to be here. So thank you. And Julia works on the coalition that really did help to propel this it's a big coalition, it's a statewide coalition to help propel this forward. And then I think Karen Vastine is here with us from Vermont, and I think she's the only systems provider that you guys have heard from on the panel. But Vermont actually had a series of reforms, a lot of which dealt with young people in the adult system, and most recently has decided to include children over the age of 18 as part of their juvenile justice system. Also, because she is breaking new ground, so also deserves a huge round of applause. So with that, I'm going to quickly ask Steve or somebody to hit the play button so we can get the context for Raise the Age New York, and then I'll pass it over to Julia.
Sorry. And see the subjectiveness in where someone is in their life. I was 15 and I was arrested. And the only reason why I wasn't sent to Rikers was because I had a late birthday. My friend, because he was 16, he went to Rikers. He came out a different person.
Most people were not aware in New York State that we were charging 16 and 17-year-olds as adults.
For years, New York was one of the last 2 states in the country, along with North Carolina, to prosecute all 16 and 17-year-olds as adults, regardless of crime, regardless of circumstances. Finally, in April of 2017, Raise the Age became law.
Raising the age is a bipartisan issue. It's something that it's right for kids and it's right for communities, but it's also what's best for public safety.
To stigmatize a 16-year-old for the rest of his or her life because of an error in judgment or a mistake is really unfair.
The law has a lot of different pieces, and they go into effect at different times. As of October 2018, the age is officially raised for 16-year-olds who are arrested and for 17-year-olds as of October 2019.
It is definitely a step in the right direction, but in many ways, the hard work is just beginning. We will need the funding, we will need the system changes, we will need the facilities that are in place, and to do that, we really need to continue to have watchdogs who are looking at the implementation of Raise the Age to make sure it's done correctly.
Now, young people won't end up like my friend, and Raise the Age gives that opportunity.
So thank you all for being here. I mean, this is an incredibly important moment in New York. So it's great to see you here in this room this week in particular. I want to tell you a little bit about how Raise the Age works. It's complicated, and it really reflects the fact that this type of reform impacts all parts of the continuum for children and families. So the law was passed a year ago. As the video gives you a sense of, it really rolls out in two phases. And the first phase of it, which started literally on Monday, is that we no longer prosecute 16-year-olds as adults automatically, which is why, up until Sunday night, we had 200, or 100 actually, 16 and 17-year-olds on Rikers Island.
My name is Dr. Daniel Choi.
One of the, so in addition to this piece where we're changing, where we are raising the age of criminal liability, we're changing our court system enormously. So today, 16-year-olds who are charged with a misdemeanor go to family court. And the family court is really the appropriate setting for young people. This is a setting that's confidential, this is a setting that's rehabilitative, and this is where young people are treated as kids in the context of their families and their communities. That means they have resources and the opportunity not to leave this system with a permanent criminal record. It gets more complicated when we talk about felonies. As of today, we have a new part of our adult criminal court. It's called the youth part. And under the law, this is a new court that exists all over the state for 16-year-olds who are charged with a felony. Once charged with a felony, if it's a nonviolent felony, your case will most likely be transferred within 30 days to the family court, unless a prosecutor decides that there are extraordinary circumstances that apply to the case. The law does not define extraordinary circumstances. This is going to be an enormous opportunity for defense attorneys to really narrow the scope of that. It's also an opportunity for prosecutors to enlarge the scope of that. And we as advocates who will be watching implementation of the law are looking very closely at this. There's a lot of different opinions about whether or not that extraordinary circumstance is going to result in many kids prosecuted with nonviolent felonies in the adult court. And frankly, we just don't know yet. If you are brought in on charges with violent felonies, you will also go to this new youth part, this adult court. And you will most likely stay in that part, although there is the opportunity to transfer under certain circumstances to the family court. This is a complex system, and you've probably been reading, if you've been watching some of the press over the last week, about some of the concerns about these complexities. There are also changes in probation. There'll be probation staff that sit in this new youth part that will be available for voluntary services for children that come into that youth part. They can have a voluntary assessment and voluntary services. There's also great debate about that. For some people, they have a right to be accompanied by counsel, but there are many concerns about whether that potentially opens up some net widening for young people to get further entangled in the system before there's been any finding of criminal liability against them. So in addition to these pieces, we have new parental notification obligations. So formerly, 16-year-olds' parents were not notified if they were arrested. They were questioned in adult settings instead of in settings that were appropriate for their age and developmental state. Now, those obligations which were created in the family court will apply to the 16-year-olds this year and to the 17-year-olds next year. So we have these court processing pieces, we have this arrest and parental notification piece. We also have new rules around detention and placement. So as I told you before, last week, 16 and 17-year-olds were sent to Rikers Island to be in an adult facility. And that is just as true across the state. 16 and 17-year-olds were detained in adult facilities. But as of today, that's no longer possible for 16-year-olds. So here in New York, 16-year-olds are now placed in what is known as a specialized secure detention facility. It's a new type of detention facility that is overseen by our Office of Child and Family Services, a state agency that is all about juvenile justice and child welfare, as well as our state system, our state correctional system. So those two agencies in most regions of the state have been certifying these new settings, specialized secure detention, for the youth who go to the youth part who are charged with felonies. A 16-year-old that goes into the family court will go right into existing juvenile delinquency detention settings if they require detention. So there's a change here in terms of the facilities and where kids will be placed. And the purpose of that is to really reflect the fact that young people, children, living in adult settings puts them at enormous risk. I'm sure you've heard the story of Khalif Browder, the experience of children in settings, adult correctional settings, setting aside the exposure to solitary confinement, which is an enormous problem for all people, and especially young people. But adult settings, in general, are not rehabilitative. They don't reflect the needs, the developmental needs and health needs of young people. So it's important for them to be in settings that meet those needs. I'm sure there'll be many questions about sort of the intricacies of the law and how it's rolling out. I'll just say one more thing about it as I give you this kind of opening gambit, and that's that this is a state and local partnership, like much of juvenile justice reform, and that presents challenges of its own. These systems really operate at local levels: local judges, local police departments, local detention, local lawyers, local probation. And the funding here that's been appropriated by the state is about $100 million just for this kind of court processing, probation, and services piece, and that will be drawn down by each community. But implementation will really be defined about how communities choose to use these dollars, how well they train their staff, and how these systems operate, which presents really an enormous challenge in implementation and, from our perspective, from monitoring, where we were once really focused on Albany as our target. Now we really need to look at over 50 counties throughout the state and look very carefully at how each community is embracing all of these changes, and there will be unique barriers and challenges in different parts of the state based on how these systems were working before the law and based on their embracing the reforms that are before them. So I'm looking forward to your questions, and I'm sure there's more to say and answer, but that's kind of a big picture of where we are with Raise the Age today.
And I'm going to turn it over to Karen. I just want to highlight the reason that these folks were both selected to be on the panel is New York was the second to the last state to raise the age to 18 for 16-year-olds. North Carolina was the other state. And then Vermont, on the other end, is the very first state to push up beyond 18 as the age of criminal responsibility. So we kind of have two ends of the same paradigm.
It's true. Hello, I'm Karen Vastine. It's such a privilege to be here, and thank you for including Vermont in this whole symposium. So I can't really talk about what we've done in Vermont without talking about Vermont first, so I'm going to start there. I think probably most of you are aware of the bucolic countryside pictures of cows and barns, and that is really what most of Vermont is like. We are a very, very small and very rural state. So when Julia and I were chatting with Marcy to prepare for this panel, like the scale and scope of the changes in Vermont and who it impacts and the numbers are just completely different than what we're talking about in New York. And we also have some serious challenges because we are such a rural state, but at the same time, because of the scale and the accessibility of leadership in all three branches of government, I think that we're able to make change very quickly, and I'll talk a little bit about that too. So just by way of introduction, I work for the Department for Children and Families. The commissioner is Ken Schatz. For folks who have been around for a while, you actually may recognize that name because he was the president of the Coalition for Juvenile Justice for many years. And before, way back in the day, I think it was maybe his first or second job after working at Vermont Legal Aid. He was the chief public defender for juveniles in Vermont. So this is somebody who's been working on juvenile justice reform for a pretty long time. So when he was actually appointed as the commissioner of the Department for Children and Families, the first thing I said to him is, we're finally going to get it done, aren't we? So I appreciate what Marcy was saying in terms of highlighting that Vermont is sort of ahead of the curve, but actually we were well behind the curve until 2 years ago. We only raised the age, if you will, in terms of requiring where prosecutors file cases for 16 and 17-year-olds. We only made that a requirement in 2016 with legislation that passed. So just to let you all know that it's a dubious distinction that we were so late at the game, and now that we've sort of taken a little bit of a leapfrog approach, now that we're looking at including 18 and 19-year-olds in family court. So I would just also want to highlight something that Julia said, that where we are in Vermont absolutely could not have happened with the collaboration that we have of our stakeholder group. So when I was talking about the scale and accessibility of people in Vermont, it's not unusual for advocates and workers in the system to have access to the chief administrative judge and the defender general, the executive director of the state's attorneys. Like, these folks are actually quite accessible. And so what I've been doing for the last 2 years in my role at DCF, since this legislation passed, is I've been working with this group to try to refine the law and also have an eye towards implementation. So I think it might be helpful, too, just to talk a little bit about how we got here, and I know Marcy's going to also bring that around for us as well. But in Vermont, our conservative laws with respect to juvenile justice came about in 1981. You probably remember hearing this from many of the speakers yesterday that, yep, Vermont ticked all the boxes for what happened. We had a horrific crime committed by a 15 and 16-year-old against two 12-year-old girls, and that it resulted in a special session of the legislature because once the boys were caught, the 15-year-old, it was clear at the time, would only be able to be held in custody until his 18th birthday. So people were outraged. The horrific crime preyed upon everybody's fears and their worst imagination. And so as a result, we've had this law on the books for a significantly long period of time. So I should also share, back again to like the country folkiness of Vermont, that our chair of the Senate Judiciary Committee in the 80s actually ran a residential program for youth who were engaged in the system. So I think that in some ways this really hit him in a different way than many other policymakers. And because of his view and lens on this, for the longest time, and he would not mind me sharing this quote with you, he always felt that if a kid if they were old enough to do the crime, they were old enough to do the time, until he realized how adversely that was impacting youth in our state. And so we've been kind of slowly chipping away at doing juvenile justice reform. So, and for us, I can tell you, because I've been working on juvenile justice reform since the mid-2000s, that we've made numerous attempts to change the statute. And that at the end of the day, what won the hearts and minds of Vermonters and policymakers was the work that we did without making statutory change. And I think that this is something that may be helpful for you all to be aware of, is that there's so much that can happen without legislation to legitimize the changes that are needed, and for states to think about youth as kids and not and to remember them as kids and not as a case. So leading up to 2016, when we finally passed this legislation, we were doing a number of things, and I haven't heard this come up yet, so I'm going to mention it now. So Vermont in the mid-2000s really embraced risk-need responsivity in terms of supervision of youth. And so what we're looking at here is not just what was the act that led the youth to land in court, but what are their protective factors, and then what are their risks to reoffend. So we, for many years now, have been making a concerted effort to blend the risk need responsivity principle with their adjudication and what the expectations are for youth on probation or youth who are housed in our secure treatment center. So this has actually been a very important aspect of our reform. In addition, our state advisory council has just been unrelenting. They funded a recidivism study. They did projects to encourage prosecutors to use family court through training and outreach. We did presentations after presentations on collateral consequences and adolescent brain development. While we believe that the reduction in violent crime in general in Vermont was a factor with helping to move this conversation along, at the end of the day, I think it was a change of heart of Senator Sears from Senate Judiciary. And I think that really came about with some good old-fashioned peer pressure. And so I also just want to say that I think that, especially in such a small state, peer pressure works wonders. I mean, we talk about how that actually is such a governing principle for how youth's impulsivity and their decision making. But I think we should also just acknowledge that it can also be very effective and a tool for getting people to change their minds. So that's what I just wanted to share with respect to that. And Julia described a very complex, system here in New York, and we are also, enjoying a very complex system ourselves in Vermont. But at the end of the day, without getting into the specifics of our laws, I think what would be helpful for you all to know is that in 2016, as I described, we enacted legislation that no children under 12 can be prosecuted in criminal court. So yes, that was on the books, that they could be prosecuted in criminal court. And that 16 and 17-year-old cases are required to start in family court, and that no misdemeanors can be transferred to adult court. And when Marcy was talking about that every state has their exceptions, we have our exceptions as well, and that's what we call the Big 12. So the Big 12 are more egregious and violent offenses. And then finally, we have this hybrid status called youthful offender status. And when I was talking about ways that we've chipped away at getting towards raising the age, we did come up with this hybrid status in 2009, which allowed for 16 and 17-year-olds to actually go through the family court process, but only after they had pled guilty in criminal court. And the thinking there was, of course, everything that we've been talking about the last day and a half, which is that the Department for Children and Families, which provides supervision of juvenile delinquents, has access to treatment, and because we use a social work model for our supervision of youth, that the feeling was that youth would do better in our system. So the way that it works is that a youth who is assigned this status is actually given both a social worker from DCF, and then they are also assigned a probation officer from the Department of Corrections. So there's sort of this, if you will, there's kind of the long arm of the law with the Department of Corrections, in that if a youth does a significant act and violates their terms of probation, that they could actually be transferred to the Department of Corrections. For the most part, all those cases always ended up just being supervised by the Department for Children and Families. So that's where we are now in terms of 16 and 17-year-olds. And I'm sorry, I'm going on too long. And then finally, so this past year, we enacted legislation that would raise the age to include 18-year-olds and 19-year-olds in 2020 and 2022, respectively. So we're at the pain point of looking down that, figuring out how we're going to make that reform. And while it's exciting, it's also it's daunting to think about the system changes that need to happen to ensure that we're doing a good job for 18 and 19-year-olds in our state and getting it right.
Thank you. So I want to take pause for just a second before, because we do want to open it up for questions, and then I've got other questions that we'll wrap with for the panelists. But I do want to take pause for a second and highlight a couple things. One, New York has, since the inception of the juvenile court in New York State in 1909, has had 16-year-olds as adults, charged as adults, and 17-year-olds, no matter what the crime, no matter how minimal, right? And Karen mentioned a case in the 80s that was sensationalized, that drove policy. We know what a bad idea that is. We know the terrible outcomes that happen. But it's taken this long to get us this far, and I think a lot of that has been because both these states have made intentional policy changes to de-incarcerate children and get them served in their communities, and have shown better outcomes as a result of that. So that there is a willingness, right? But I still want to hear the shock value. We're celebrating still that 12-year-olds aren't certified as adults. That wasn't that 12-year-olds can't go to family court. That was that 12-year-olds can't go to be certified, right, as adults. In New York, it's 13, right? So these are great things, but I do want to drive home that when I'm talking about carve-outs, the kids who are left in the system after these reforms are children with complicated histories, with quote-unquote violent felonies, which in some states can be a burglary when no one's home, can be me yanking a cell phone out of Julia's hand, can be... Our definition of felony is so broad in our country now that we really have to redefine violence, if you will. And then the last thing I'm going to say is the racial disparities are awful. And we are creating two very different systems. So these have to be struggled through, and they have to be embraced. And we do need a heart. I mean, Karen, I appreciate using that language. We need our heart. We've gone so far that we need our hearts and minds to remember that these are children. And I think the immigration debate that was just here before us, it's the same. It is the next super predator movement. And it's happening before our eyes. And these two things are incredibly connected. So I'm going to say that. I think we're going to open up for questions from you guys for a little bit, and then I can wrap up with a couple other questions with these guys. Oh.
Hi. I'm covering Raise the Age here in New York for the Chronicle of Social Change all across the state. One question I have for Julia, but I also want all three of you to weigh in. There's so many levels of the system that are changing under this law. I'm wondering which part you're most concerned about. I know there's so many things that have to go just right for this to really kind of play out the way advocates are hoping. Is it the DA's discretion? Is it the judges and the youth part? Is it the quality of the facilities? Is it Horizon? And I'm wondering if Karen and Marcy, you could speak to how does that compare to other states that have recently raised the age? What is usually the top concern of advocates who are watching these reforms play out? Or which part of the system are they most worried about kind of living up to the spirit of the change?
Day 3, it's hard for me to predict what to worry about most, to be honest with you. I think what we are really focusing on is, do we have the right strategy to watch all these pieces of the system? And we know that there's been an enormous amount of training for the judges. There's been trainings for the attorneys. There've been trainings for probation. The facilities are coming online. But all of these pieces of the chain and pieces of the continuum are really essential. So at this point, I really can't identify one specific thing that I'm most concerned about. I think the challenge in a coalition like Raise the Age is that we represent impacted people. We also represent folks that are service providers, they're judges and attorneys, and so the coalition really has to keep an eye on all of those pieces. And so we need to make sure we maintain the relationships with those folks to connect and collect that information, and also to continue to convince everyone, stakeholders, journalists, administrators, and those who are part of our legislative system that the work is not done yet. And that challenges that may emerge that are inevitable don't tell us to move backwards.
I want to just real quickly, the other thing we got to think about, this is going to affect 25,000 kids a year in New York. I mean, 25. What other reforms are going to get 25,000 kids out of the adult criminal justice system in New York? I don't know, And so, once the 17-year-olds are included. So there is numbers, and I think the thing we all have to remember is that those kids are mostly there for very low level. We've heard this for 2 days now, but it's true. And what the system naturally does, from the national perspective, is worry about the deep end beds. I mean, that's what's on the news with Horizons. They're not in the courtroom. I was in the courtrooms watching yesterday. There was all this anticipation. There's going to be kids lined outside the door. We're not going to have the judges in order to do this. There was 4 cases all day. And that, and they're like, well, there was 1 yesterday. There was none the day before, So the floodgates aren't happening because there's, again, the front door protections in family court that presume to not detain. So to me, nationally, the biggest problem is we cannot get system stakeholders, and when I'm talking about that is largely driven by legislators, to get off of seeing kids as violent. Still, that violent narrative is there, and that we need beds. That is our biggest fight in every single state we go in. Their youth facilities are 3/4 empty, and they still feel this hunger to build beds. And that is the conundrum and the point of which I think the work that we do intersects really closely with the work that you'll hear from with Liz Ryan later today. I don't know if you have anything to add.
Okay. Thank you for the question. I think I hadn't realized how much I wanted to be asked that question until you asked that question, because I think it really gets at the heart of what we as policymakers and systems folks need to be thinking about and sharing with you all. One of the things that is, I think, important to know about the Department for Children and Families is that we have what I believe is a very unique system with respect to we have a combined child protection and juvenile delinquent system. So the Family Services Division within DCF has social workers that work with families whose children have come into our custody because of abuse, neglect. And then we also and those same social workers may also be providing supervision and support to a youth who has been adjudicated delinquent. So the reason that this is important is that Vermont, for many reasons, has been very susceptible to the opioid crisis. So the numbers that we've seen of children coming into our custody, especially for children between the ages of 0 and 5, has just gone off the charts. We've never had numbers this big in Vermont. And I think we're all aware with child protection that the pendulum swings back and forth quite a bit. If you were to map out child welfare over the last 50 years, you'll see that every 10 years or so, the pendulum swings towards having more children come into custody, and then it swings back to having fewer children coming into custody and more support for parents. And I would say we're definitely on the uptick in terms of children coming into our custody. The reason that this is important is that our family courts are incredibly strained by this influx of children coming into our system, and we have been trying to figure out how to solve this issue. So raising the age, coming back to that, what we would be looking at in terms of the potential universe of cases that are currently going through adult court for 18 and 19-year-olds, if they were all to come through family court and to be supervised by DCF, that would be a 400% increase in our caseload. I'm going to use percentages because our numbers are so silly compared to Liz's. So it's like 1,000 kids. So I know that doesn't sound like a lot, but it's a lot for us. So just to share it with you, I think that we just have concerns about what's going to happen with our system, and so it's really family court and and the Department for Children and Families. At the same time, we're incredibly supportive and want to make this change happen, and we're so proud of our state for moving this conversation forward. So I'm constantly holding this dichotomy of yay, we get to have this conversation, and isn't that amazing? And oh my gosh, how are we going to get through it? So thank you for the question.
Is that pretty common, would you guys say, the child welfare system is coming under pretty tremendous strain with these raise the age laws being passed?
Well, I think the child welfare systems are getting strained because of the opiate issue, not because of raise the age. Yeah, but they're the intersection between child welfare and JJ is big. So, but I don't think that it's because of raise the age.
Hey, I have the next question. I'm Co. I report in Jackson, Mississippi for the Jackson Free Press. Our minimum age for juvenile charged adults is 13. So it's inspiring to hear any raise the age work going on. I have a question more so about racial disparities in the system, and as you guys are working on this legislation, what that looks like in terms of addressing the number of youth that come through that are black, and Vermont has an outrageous number of black people incarcerated compared to what the 1.3% of black people that live in the entire state. So I just kind of wonder how that plays out at the juvenile level, and just kind of what you see at the outset of how many white kids go through immediately through the family court system versus any other system. If you could kind of talk about that also.
That's a great question. And so we have what I was describing as a secure treatment center. We moved away from having a detention, and we actually have been drawing down Medicaid funding for a secure treatment center, or we were in the past drawing down Medicaid funding. And so Woodside, which is our secure treatment center, you are right, has had a disproportionate number of youth of color who have been placed there. And so we first looked at those numbers, and Vermont is so teeny that we have to look at 3 years of data to even get a significant finding. So we do have challenges with the data. But that said, we have one county in particular where we're seeing disproportionate minority contact. And so we are actually, at this point, working with our state advisory group. We have a couple of grants going into that community to really support community mentoring. I think in Burlington, which is the only city in Vermont, that's actually it's a refugee resettlement site, and so it's a lot of new American youth who we're seeing ending up in the system. And so we've actually been working a lot with what's called the Association for Africans Living in Vermont to help youth feel some connection to their community. I actually used to be a community provider in Burlington. I ran a community justice center. And I can tell you that one of the things that we were starting to see is that youth coming into Vermont were feeling extremely disconnected from the community, and then they were also feeling disconnected from their own families. And so it was sort of leaving them in a bit of a lurch. So, and that's when we actually started seeing more kids coming into the system. So that's one of the things that we're trying to unpack by very strategically working with community providers. So we're doing a lot of front-end prevention work, and then we're also working with the state's attorney to do case reviews to analyze why did you make this decision, so that we're kind of shining a spotlight on making non-biased decisions, if you will.
So disproportionality in New York is a very real issue in the juvenile justice system, and our system is just as oppressive for black and brown kids as it is for the adult system. And it is such an enormous issue that on the 21st of last month, when the city held a meeting of all the stakeholders who are working on Raise the Age, we had several hours of discussion where we were, as a group, really looking closely at the data on our kids over time and confronting some of these enormous problems. I think I'll say two things. One is that Raise the Age is intended to make an impact on that, in the sense that it's intended to serve those kids. It's intended to remove those kids from systems that burden them with permanent criminal records that impact everything from housing to education to employment, and then the list goes on and on. There's a ceiling provision in the law, which actually is already in effect, that is the ability to try and confront some of those collateral consequences. But I don't mean to not answer you directly, which is that the law doesn't have in the language of the law, a specific strategy for addressing disparity. And I think the ways that the state can do that and the things that we as advocates are looking at are a couple of things. One is we're looking at data, administrative data that will come out of these systems to see where counties are and what's happening to kids, and looking at race, ethnicity, and age. We need to keep an eye on that. We're also working on putting together a court watching project that's going to be in the courts, in the new youth part, and in the family courts. And that observational opportunity is a way to look and collect information, which will include that demographic information. And it's also the value of the accountability of people in the room watching these exchanges, watching decision-making happen. So it's something that we are very committed to investing in, and I think the city is really spending some time looking at it, but we're in the early days.
And Cole, just real quickly, we just published a brief with the National Association of Social Workers called The Color of Transfer. And it actually looks at 3 states, Florida, Missouri, oh my God, I'm blanking on the third one, and the history of racial oppression in those places. Missouri right now is the only state where the judge is supposed to take the disproportionality of their finding into consideration before they transfer, and they have one of the worst disparities in transfer in the country. So even with that there, I'm telling you, we're still letting the charge drive we're not letting the kid, we're letting the charge drive the transfer decision. Somebody back there. Oh, sorry, I didn't mean to.
Hi, I'm Cassie Feldman from The Appeal, and I have another New York question, which is a lot of local coverage has been focused on the staffing at Horizon, and just wanted to know sort of how big of a problem is that, the fact that it's COs, the COs don't want to be there, sort of, and how will that affect the youth's experience and sort of what's next in terms of that particular issue?
So Horizon is the juvenile facility here in New York. It was formerly used for juvenile delinquents and currently is being used for our new adolescent offenders, which are 16-year-olds charged with felonies. Pardon me, that's what it will be used for. It's currently housing our Rikers youth, which are the 16 and 17-year-olds that came off Rikers. The city was unable to staff this facility by this date with a new staffing group called YDS's Youth Development Specialists, and it has instead brought over correction officers from Rikers Island to temporarily staff the facility. So the Raise the Age campaign has been on the record saying that we think it's not an appropriate staffing, and that the need for the youth development specialists is pressing, and that the city had initially said that that was going to be a 24-month plan. And I think through the advocacy of ours and many others, they've now pushed that down to 18 months, and the YDS staffing and recruitment is ongoing. What we are hearing about and seeing, in Horizon is something that is very concerning to us. But I think it's also something that we want to make sure that we want to make sure that kids are safe. But we also need to let this new staffing model that blends the Administration for Children's Services programmatic staff with security. We have to watch it closely, but we cannot retreat to moving these kids back to Rikers or putting them in another setting. And so, we are in a moment where certainly we're watching this closely. I know that there's been an enormous amount of coverage. My concern is that an overreaction to this may push us back to where we were several weeks ago, instead of moving forward in a way that really lets this model play out. And I'm hoping that what we are going to see moving forward is a better collaboration between the Administration for Children's Services and correction officers getting used to working in this environment under new rules, which are very different from those that apply on the island.
Thank you. This question is for Julia. Julia, I'm wondering if you could tell our fellows how you and others organized the coalition that brought about the Raise the Age change in New York. In other words, what did it take in terms of organizational skill, and what stakeholders you had to bring into the tent?
So this work has been going on for many years, 20 years, 30 years. There have been people that have been working on reframing the understanding of young people in the New York system. The Raise the Age campaign began formally in 2013, and it was really a combination of Children's Defense Fund New York and the Citizens Committee for Children, also a New York-based organization, bringing together stakeholders that really started with impacted children and families, the defense bar, thinking also about how to engage district attorneys on these issues as very important allies, how to engage police, as you saw in the video today, crossing some lines in terms of the sort of traditional poles of these arguments to build alliances also with providers and people that were seeing these kids outside of the system, and thinking about the ways that we could also frame the debate in two new ways. One, about what we know that's become a consensus in the science about young people's brain development, and building that into our conversation so we had a common language about who we were talking about, not necessarily through the lens of sort of our prosecutors, our judges, our individual experiences, but seeing this as part of a real shift in our understanding of what kids' needs are and how they operate in the world. Bringing all of those people together was challenging, and the law is not a perfect law. And the law was not passed the first time around. And so I think some of the challenges in this coalition work was finding common ground, finding ways to compromise, also making promises that we weren't going to stop with what we got. We recently put out a statement with the law implementation this week, focusing on 6 more areas in terms of things we didn't get with the initial law that we need to go at going forward. And I think that in any coalition, there's a range, a real continuum in terms of political and other interests in the reform. And the challenge is to find the areas where you can work together and to take that work and break it down and think about how we develop an effective social media strategy, which we did from the very beginning, how we engage some of the biggest communities that were impacted by the law. So it wasn't just New York City talking about this. It was Onondaga, it was Monroe, it was all over the state. So we could really characterize this as something that impacted all of our communities. And it was also to be very sophisticated. I mean, we engaged PR firms, we engaged really effective kind of social media and communication strategy around this. And so in addition to taking many, many years, a lot of different voices, working through challenges and conflict, finding areas that we wouldn't be able to agree on and agreeing to set those things aside, this was an operation that was a mix of grassroots work and very sort of professionalized work. And I think that having that kind of up and down, left and right, breadth and depth was the way we got it done. The discussions that led to the compromises, were really part of conversations that Children's Defense Fund and CCC helped to drive. There are many other organizations that have been involved in this work. Youth Represent, you saw in the video. There's also been Legal Aid and others. But we, as kind of the co-leads, CCC and Children's Defense Fund, were the ones that really had to keep moving things forward in terms of the reform.
It's Josh Vaughn with the Sentinel in Carlisle, Pennsylvania. So when you refer to, in your jurisdictions, the age of responsibility, does that refer to the age at the time of the offense or the age at the time of arrest? And how do your states deal with people who are accused of committing an offense under the age of responsibility but not arrested until they've aged over the age of responsibility?
I think that's a complicated question. I was actually watching it unroll yesterday when I was going to observe the youth part. So there's a couple things. One, no matter where raise the age has been passed, it hasn't been retroactive. And I will say stakeholders, I got calls from a ton of DAs in New York maybe a month ago, was it? They were like freaking out. They're like, we have these 16 years. We know in a month that they're going to be protected by this law. Like, what do we do, right? A couple of them were going to turn 17. Like, so there are people that are focusing on this, trying to say, like, we need to do as much as we can to stop damage to the 17-year-olds now that we know they're coming right behind the 16-year-olds. But laws don't go that clearly in depth, so they're really struggling through it. I'm saying that as an outside observer because I don't know. But I will say in all states, it depends on the charge, right? And it depends on where those age things are. So we're saying age is I'm delineating 18 and then in Vermont 20 is the age of criminal responsibility. But as somebody asked earlier, we got to be really clear that there's many ways for kids to get in the adult system, right? A judge can waive them. A state can have prosecutorial discretion. There can be statutory exclusion or mandatory transfer provisions. There can be once an adult, always an adult provisions. And there can be the age of criminal responsibility. So there are many, and there's blended sentencing. So there's a lot of ways. We did not make this simple. And states, many of them embrace all of them. So we're trying to target the piece that has the biggest impact, but these other pieces, as Julia just mentioned and as Karen identified, they started with direct file in Vermont and then are now working back the other way. But there's these things all bounce and are tied together that it's very, very complicated. Sex offenses is the one that you guys, I presume that's why you're asking, and that is really difficult. And we actually have a spokesperson in Illinois that I'd like to connect you to because her son got arrested for a crime that happened when he was 14, when he was 19. And that is where this problem exists. And they are trying, and many states, they're doing two things. They're trying to not make juvenile record sex offense registry mandatory or limiting the thing for juveniles, but they're also extending, because of the Me Too stuff, they're also extending that statute of limitations. Thank you for the words. I think we're going to see more of it.
Hi, I'm Jonah Newman. I'm from the Chicago Reporter. I guess I'm curious, and obviously it takes a lot of compromise to get these things passed, of course, and one of those, and Marcy, you mentioned this a little earlier, is this distinction between violent and nonviolent offenses. And I guess I'm wondering if you each can kind of talk about how do you ensure that line doesn't get used to, have police arrest people on charges that may qualify as violent when otherwise they wouldn't have, or sort of further stigmatize things that they're still kids who are still engaging in perhaps kid behavior, and so kind of how do you address that?
I mean, I think this is the next wave of juvenile justice reform, is how we think differently about quote-unquote violent crime. And this is I was just talking with folks in other states a couple of days ago, because this is really, in some ways, after a law like ours in New York, that's one of the places you need to go. There are enormous challenges in that, and they have to do not only with how we mitigate public safety, which is an essential part of Raise the Age, is that we're saying this is better for kids and this is also better for public safety. So how we make sure that we can really respond to concerns about violent crime that address concerns about public safety. And I think that one of the things that we have the benefit of under the Raise the Age law in New York is that we'll be able to watch very carefully, county by county, how these two systems work, how the violent and how the nonviolent charges work, where they go, what decision-making looks like from the perspective of prosecutors, which I think gets us ready to have a more effective conversation about how to do that. I don't think it's surprising that there are carve-out rules and and transfer rules all across the country. It's because this is an enormous concern. the way, I think, to address it is with data information, and I think New York could be really valuable in that, depending on what we see in terms of results coming out of our counties over the next year.
A great question, and I would agree that it's still a work in progress for us as well. And I think that this is part of the reason that we are stressing the need for continued and expanded use of scientifically driven tools like the youth assessment screening instrument, which is what we use in Vermont to assess youth for their risk and need. Part of what we've been trying to do in Vermont is to shift away from what did the kid do, but also to combine that, as I referenced earlier, with what are their needs and what is their risk, because you can't look at them in a vacuum. And I know that just because we tend to reference these types of cases because they seem like outliers, that sometimes what looks on the front of it as a violent crime and that this youth might be very likely to recommit a crime, often we find that that's not necessarily bearing itself out and that we have to look at that. And so we've been educating prosecutors on that piece. I'm not sure that we're at the point yet where we're thinking about where and how law enforcement would file those cases, but it's a question that we're still unpacking.
And I just want to point you to California, just passed the most progressive transfer law in the country. They ended transfer for children under the age of 16 for any crime. So if you are 15, 14, 13, 12, even for the Big 12, as Karen said, you cannot be transferred to the adult system. And again, 10 years in a kid's life is a long time. If you're 15, you can still do 10 years in a juvenile state-run facility there, right? And that, for some reason, this is still considered radical. 10 years, that's most of that kid's life. It's probably all of their memorable life. It's a very long time from a children's perspective. But that is the farthest we've seen it go.
Actually, my question's related to the new California law. Oh, I'm sorry. Kelly Davis. I'm a freelancer in San Diego. And I feel like I should know the answer to this question, but can someone who was 14 when they committed a crime, you know where I'm going with this, is there any grounds for appeal of cases anywhere where, given changes, direct file and...
It's not retroactive, so you can't, but there's all sorts of things with resentencing that has also happened, so those kids can be resentenced, but they can't lose their adult conviction.
Okay.
That's the short answer, Kelly.
Hi, I'm Tessa Duvall with the Times-Union in Jacksonville, Florida. I'm curious with these reforms that you're seeing, to sort of build off of Joe's earlier question about the coalition you had to put together to get these reforms through. I also want to hear about the political discourse that surrounded these, because as I asked a panel yesterday about direct form or file, prosecutors are the reason that dies in Florida every single year. And so I'm curious, a lot of elected officials are former prosecutors and see that side of things. So how do you bring together a coalition? And granted, I know Florida is a very politically different state than Vermont and New York, but I'm just curious if you can talk about the landscape that made that possible.
I'm just going to real quickly talk. I'm going to turn this over to these guys who you want to hear this from, but I am going to talk about the fact that this year, Joe mentioned, or Steve mentioned, that it's Youth Justice Action Month, YJAM, this month, and the Campaign for Youth Justice has focused, along with a lot of other national JJ folks, on the importance of getting people to vote and hold their electeds accountable. So, 3 out of 4 of the players in a juvenile courtroom are elected: the judges, the DAs, sheriffs, right? So that matters. Those local elections matter, and that accountability. We're waiting for Florida to go blue, actually, after that ballot initiative re-enfranchises 800,000 former felons, or people charged with felonies. I should not minimize them. But what I will say is this is where the grassroots folks and the impacted communities have got to be at that table. It is hard on them to make statewide meetings, especially when professionals are at the table that get paid to be there. It is really hard for them to have an equal say, because in their reality, when I have a mom who doesn't know where her 15-year-old is sleeping that night or his safety, this law matters and the compromises are unacceptable. And so for somebody that is a lobbyist at that same table, that's a hard line to draw. So I want to underscore the complications and the absolute urgency to do this in coalition. The other thing I'm going to say, and this might be controversial, ours have led these reforms. Dems won't run and lead on these reforms in most places. We have turned public safety over to a Republican notion, and I take huge problem with that. It's good because it's been bipartisan. But in Texas, raise the age is failing because of one Democratic senator. One Democratic senator. If Texas raised the age, we are down to 3 states and probably 2 because Michigan's going to do it. And that would make this a win, right? It would make it a win. And we have one Democratic senator blocking that law from that policy from being, and he's out of Houston. And I'm happy to give you his phone number. But I would just want to say, like, I don't make the assumption politically. It's Whitmire. Senator Whitmire. He's very powerful on the Judiciary and Crime Committee there.
So in Vermont, our state's attorneys are elected officials. And so that has been very challenging to bring them to the table. And so when I was talking about, some of the work that we've done without statutory change, one of those was to do significant outreach to all the state's attorneys to really educate them. Sorry, I feel like I'm ringing the Yazzie bell today, and I had no idea that's what I was going to do today. But we were really educating them on the use of the Yazzie to understand what's going on for this youth and to encourage state's attorneys to file cases in family court. That actually significantly helped us to drop the number of youth who were going through adult court just by doing outreach to our state's attorneys. And then at the end of the day, that good old-fashioned peer pressure, 2 years ago, legislation passed that requires state's attorneys for certain types of cases for those to flow automatically to diversion, so there's a presumption of diversion. And then if the case isn't going to go to diversion, that the state's attorney has to say on the record why they're not referring it to diversion. And then as part of that, there's been a requirement that state's attorneys track and report on the number of people that they're sending to diversion. So again, that's actually a great way to hold our system accountable, is when people have to say, oh, wait, why is Orange County so much lower than the rest of the counties? Like, that kind of thing has really had a big impact. But I don't mean to sound that I'm not collaborative or anything like that, but we don't do anything without talking to each other. In our legislature, which is a citizen legislature, if we come in there and we haven't already talked through the pros and the cons of a particular bill and tried to come to a compromise before we even talk to the committee, that bill is likely to die. And so because of that, I think that there's just a number of ways that we've been able to work together on that.
Hi, I'm Art Levine of Freelance Juvenile Justice Information Exchange. Can you just help clarify? This is a nomenclature issue. Maybe things vary in different states. You keep referring to family courts, and I've sometimes heard of family courts where there's civil issues involving families, husband and wife are in a dispute in custody, and there's a family court judge who then makes a civil decision about custody and divorce and so on. So can you explain, in your states and in general, when you all are using family courts, is that in some states that also includes something that in other places are juvenile justice? Please explain this sort of confusing nomenclature for us and me. Thank you.
So these courts that we're talking about are different in different states, and the family court that we're talking about here in New York that are going to hear the 16-year-olds who were formerly prosecuted as adults is a court that handles juvenile delinquency. That is the court that we're talking about. These are often judges that are hearing foster care cases and child welfare cases. So they're courts that are very familiar with the needs of vulnerable children and families. But these courts are very different across the country, and in some places the child welfare system is distinct. The courts are different in terms of the scope of their jurisdiction, whether it's child welfare, whether it's visitation, or the rights of parents to children. And so it's important in whatever jurisdiction you're looking at to get a sense for what the legal restrictions are of each court. But here in New York, we're talking about judges in the family court who will be adjudicating 16-year-olds in the context of juvenile delinquency law.
I think Julia's answer covered what happens in Vermont as well.
So last night I saw a report on NBC4 about Horizon, and they showed video of a fight that happened there, and the overarching theme of the story was it's so violent. If I took a shot every time I heard the word violent, I probably wouldn't have made it here this morning. So I just wonder what, you guys feel like media responsibility is. I mean, there was a statement from an official, but it was mainly interviewing former correctional officers at Horizon and Rikers who just felt like it was violent. And I just feel like those kind of narratives about juveniles in the system are common. So what do you guys feel like reporters' responsibility is to make sure we're doing balanced work and not just taking what correctional officers say at face value, or unions?
I think it's essential that journalists understand the perils of characterizing children as violent. And it's also important to understand that these settings are complex. We need to make sure young people are safe. But we need to also understand that our reporting has an impact on the ways that reforms unfold. And it's important to make sure that we have stories that are carefully constructed to reflect the vulnerability of children, and don't adopt messaging around their being threatening to the systems.
Especially on video, when we already know how disproportionate our deep end systems are. You are reinforcing a message that is structural in nature and is based on racism in our country. So you cannot do it. I just don't do it. Don't do it. Please, I beg you all, don't do it. It's not irresponsible reporting, and you need to have a balance between holding children accountable and holding systems accountable, because we are quick to blame the child and the family, and not so quick to look at where some of the either system weaknesses are, right? And I want you all to read James Foreman's book, because he talks about Black communities for years asking for resources, and the only resources that will get to their community is money for policing. That is by design. That is by design, and it is problematic.
So I thought I would also just share some examples with you all of how really solid reporting has shifted the conversation in amazing and powerful ways in Vermont, just so that you also have that to work with. There's the do's and don'ts, and I would like to just talk a little bit about the do's. So I think 4 and 5 years ago, there were 2 articles in the New York Times about restorative justice. And both of those articles did such a great job of nuancing the impact of this youth's behavior and their crime on the family and on the victim and on themselves. And it was just an incredibly balanced article. And there was the one article I'm thinking of in particular. I know inspired many of our policymakers to want to have an international conference on restorative justice in Vermont, and looking at ways we could expand application of restorative justice in Vermont. And so I just want to put out there that I think really balanced reporting can be very, very helpful to those of us who are trying to make change in our systems. And I'll also share that last year, when we were discussing raising the age to 18 and 19, it just so happened that the Boston Globe featured an article on the Patriots Foundation, which was in support of juvenile justice reform. And so say what you will about the Patriots, but there are a lot of Patriots fans in Vermont, including our governor, and I think that this is one of the things that it was like, oh, right, this actually is something that we care about and that an organization we care about cares about, so we care about it too. So I know it may just sound sort of funny, but it actually helped to shift and move our legislation forward. I wasn't actually sure at the beginning of the session where the 18 and 19-year-old piece would go, and there were a number of things that helped to move that conversation along. And then finally, when I was kind of doing a deep dive and looking and preparing for today and looking at that case that I described from 1981, I was just curious about the reporting from that time. And I came across a Washington Post article that came out maybe 5 years later that was actually criticizing a book that had come out featuring this case. It was called Loss of Innocence. I think the book title's been changed now, and I can't remember the new title, but it's by Peter Myers. And I so appreciated reading this article that was just kind of laying out there that this author didn't see both sides of the situation and really vilified the two youth who were involved and didn't take a balanced view. So it's just interesting how these things can move the conversation along, and I just would encourage you to keep in mind that system reform is really, really messy, and it's hard, and it doesn't happen overnight. And I don't know that our general public understands that these things we don't just like snap our fingers and suddenly 18-year-olds are going to be supervised by DCF. Like, it's just not how it works. So I just appreciate that you all are here and thinking about how complex this is, so that our general public understands both the importance and the enormity of these types of reforms.
So this is a really positive note to end this panel on, I think, because after all, that's why you're here. We don't want to pat ourselves on the back. There's nothing that's harder to cover than systems and systems reform. It's always a balance between anecdotes and analysis, but hopefully out of this panel and all the other panels, you'll be inspired to and motivated to do the kinds of stories that actually do drive policy change. Journalists aren't necessarily advocates, and they shouldn't be, but they're certainly in the forefront of ways of making people rethink and reimagine problems that most people think they already know all about. So please join me in thanking our panel. This was a really great way to... We'll take a 15-minute break and come back. Speaking of the media and speaking of writing about juvenile justice, we've got an author who will tell us about her book and what she did and why she thinks the war on kids is still going on.